Please rise. The justices of the Appellate Division Supreme Court First Department. Meeting all persons having business with the Appellate Division. You are near, if your attendance, and shall be heard. You can see it.
Good afternoon. Welcome to the Appellate Division, First Department. I'm about to call the calendar. When you hear your case called, please identify yourself and indicate to me the amount of time that you request for your argument here today. All right, the first case is People versus Jose Miranda. Mark that submitted. People, 2497 Realty versus Furtas.
Yes, Lawrence D. Patinsky for plaintiff appellant, requesting 5 minutes and 3 minutes.
Good afternoon, Michael Kaplan from Law and Science Center on behalf of the respondents. 3 minutes, Your Honor.
All right, 5 and 3 for the appellant, 3 for the respondent. Thank you. In the matter of V, children, we'll mark it submitted. Rivera versus New York City Transit Authority.
For the appellant, Robert K. Griner, 4 and 1, please. For respondent, Arthur Schwartz, I'll take 5.
All right, 4, 1, and 4. Building ABI Enterprises versus 711 2nd Avenue.
Michael R. Curran for defendants, appellants, Your Honor. 10-5.
Do we have a respondent? All right, 5, 2, and 5. Thank you. Guevara Ayala versus Trump Palace. Submit. People versus Pablo Pastrana. Right, I understand that the respondent is trying to furiously get down here, and we heard from them. So I'll give you 5 and 2, and when that person comes down, I'll give them 5. All right, thank you. Nespoli versus Board of Trustees. Do we have a respondent? 6, 2, and 6. Thank you. Levin versus Levin.
Kevin McConnell for appellant, 7 and 2, Your Honor.
For the defendant respondent, Your Honor, Matthew Schwartz, something 7, please.
All right, 6, 2, and 6. Thank you. 862 2nd Avenue against 2 DAG. 5, 2, and 5. Thank you. People versus Victor A. Submitted. Kingstown Capital versus CPI Property Group.
Good afternoon, Matthew Schwartz for the appellants, 5 and 2.
Good afternoon, Your Honor. Seth Cohen for the appellees, 5 minutes.
All right, 5, 2, and 5. Thank you, gentlemen. People versus Dijon. Do we have a respondent? 5, 1, and 5. Pala Holdings versus Rolta is submitted. Masonic Lodge versus Fraternidad Realty is submitted. PricewaterhouseCooper versus Cahill is submitted. Our first case for argument on the calendar is 2497 Realty versus Fiertes. You may proceed.
Good afternoon, Your Honors. My name is Lawrence D. Patinski of Rosenberg and Patinski, appearing for the Plaintiff Appellant 2497 Realty. This appeal is primarily of the order of Justice Ostrager dated November 9th, 2020, and a renewal order January 22nd, 2021. Both orders relate to the appellant's attempt to have the case restored to the lower court calendars to have its day in court, all arising out of the interpretation of former justice orders, Justice Ramos, from June 9th of 2014. Your Honor, we rest on our brief and wish to make just 2 points. There's a remediation that was required to be proven as completed by Justice Ramos's order, and it was submitted to the lower
Well,
court.
Counselor, let me ask you this. The highest and best use, that's sort of the buzzwords here, right? for
That's
the
correct.
Property. And they're taking the position that it could be rezoned for residential use. Why shouldn't that be why shouldn't that argument be read into the highest and best use?
Two reasons, Judge. Number one, we demonstrated to the lower court that, in fact, the premises is currently zoned and was zoned for residential. So that's been satisfied. Whether or not it's commercial or residential, as they argue it should be, the classification of the property currently is for that as well.
Yeah, because they're arguing there's a commercial entity in that I guess in the premises, which is preventing them from doing what they want to do. Why isn't that a good argument?
Well, Your Honor, because that is not in Justice Ramos's order. That's not one of the criteria of his order. Number two, they control the property. That's their tenant. They've released and leased it to their tenant. If they felt for some reason that the property being vacant, the property building having to be demolished or anything, that should have been or could have been in Justice Ramos's order. But even further, Your Honor, that's a factual issue that we believe should be determined by the lower court after we are able to walk into that door and have the case restored.
Counsel, let me go back a minute. Did you say the property is zoned residential?
Its classification permits both commercial and residential.
And has that been true throughout?
I'm sorry, King.
Has that been true throughout? So it was zoned residential when this initial agreement was made?
I cannot say, Your Honor, that at the time that classification existed. I believe it did, but at the time that we submitted to the court to restore the case to the calendar, the zoning, as demonstrated in the, I have to cite the record, permits both zoning, both residential and commercial.
So the dispute really isn't about whether the premises could be used as a residential versus commercial. The dispute is whether the fact that they rented it out for residential long-term should prevent you from arguing that the remediation has taken place to the best possible use.
I'm not sure if I fully agree that that's their argument,
I thought the dispute had
but
to do with whether or not it was best use because it was commercial and was commercially zoned, but now you're saying something different, so I'm trying to understand then what exactly the arguments are.
the argument that the respondents have made is that because they get to determine in their sole and absolute discretion what the best use is, as Your Honor had said, they feel that it should be developed as residential, and therefore that standard in Justice Ramos's order has not been met.
But the only thing stopping them from developing it then as residential is the fact that they've leased it out to
Correct.
a tenant for the supermarket. If they somehow got rid of that tenant, it could now be developed residentially?
Correct. So in the papers, Your Honor, it is we submit to the courts, the lower court, and here, that they have an interest in this supermarket and or as the landlord at the minimum are able to determine whether the tenant should be there or not, whether they wish to keep it as a commercial, whether they wish to vacate the premises, destroy it, build it, whatever they wish to do. Whatever they decide is their right, and they can do that commercial or residential at this point. But I want to point out to the court that whether it's residential or commercial is not one of the conditions stated in Justice Ramos's order specifically. And had it been something along those lines, that could have been in the order. All the order requires is the remediation according to governmental authorities. We've submitted the no further action letter from New York State. And the best usage, we have the PW consulting report that says it is. And to counter the argument that respondents try to throw as a roadblock just to let us be restored to the lower court calendar is that, oh, they determine and it should be residential. Well, even believing that argument, as I just pointed out to Your Honor, it can be developed residential.
And counsel, let me just ask you, there was no argument below that the remediation wasn't completed, correct?
In my interpretation of the record and what was argued before the court, there was never a challenge that the remediation has not been completed.
Okay, and there's no doubt that they got the money from Exxon and they're holding it.
So I have to rely on a little bit of a phrase of upon information and belief there, Your Honor, because we've requested at least confirmation from them that they have the funds, and they have refused, respondents have refused to even confirm that fact. But yes, we believe that since the remediation is complete, ExxonMobil would have to pay. I don't believe respondents would not let the money be paid.
Okay, thank you.
Thank you.
Time on rebuttal.
Nice to meet you.
You can proceed.
Thank you, Your Honors. Michael Kaplan from Low and Science Haven on behalf of the respondents. I want to just answer some of the questions at first. Number one, the representation that the remediation is complete is false. There is an existing commercial building that sits on the site and that has sat on the site since the date of the spill. And the real issue here is that we're not at a position yet to remediate the problem. Yes.
I understand that the only remediation that was required was remediation as to specific spill number 0751061. Are you saying that there was further remediation required besides that spill number?
Your Honor, the spill number that you're referencing relates to the adjacent property.
I know.
And so the issue there is that any evidence with respect to what happened at the adjacent property is not evidentiary of what's going on in our property and underneath.
Violation on your property, and so, if so, is that violation part of the record?
Your Honor, as part of the record but was presented before Justice Ramos and both Justice Ostringer, I believe has always been our argument that there is an existing structure sitting on the building. And so nobody, not the appellant, the respondent, the New York DEC, or PW Gross, or anyone else, has ever looked at what is underneath our structure. And it's,
You're speculating that there is remediation required as to your structure?
Your Honor, I can only refer to the fact that if we look at, for instance, the New York State DEC letter, even that says, and I think it's the record at 26, that the spill is closed with the designation does not meet standards.
No, wait, did you
get-
argue below that the remediation hadn't been complete because the spill wasn't cleaned up? Or because it was, I didn't see anything in the argument below about that.
No, Your Honor, below what we argued is exactly what the...
So what you're arguing here is not what you argued below. You didn't take any, I didn't see anything in the papers below where you said the remediation has not been done.
Well, Your Honor, we certainly argued below that the existing structure is on the building, and
That's not the same thing. There's an agreement, a settlement agreement. The settlement agreement requires certain remediation. You argued that the settlement agreement wasn't complied with because the property wasn't being used for its highest and best purpose. That is completely different from saying there's still a dirty spill underneath. You did not argue that below, correct?
Your Honor, standing here today, I don't recall the transcript specifically, but I absolutely argued, Your Honor, that there is an existing structure.
I'm not talking about a structure, I'm talking about a spill. Are you saying that there's still spill to be cleaned up on that structure? And did you argue that below?
Your Honor, I believe that we argued below the fact that nobody knows what needs to be cleaned up because no one has looked underneath the
Even
building.
if that's true, then why would you resist putting it on the calendar and at least having a hearing on that? I just really don't understand your position that this doesn't even get into the courthouse door.
Your Honor, the reason it doesn't get into the courthouse door is this is not the first or second time that the appellant has tried to get in. And the standard is, in the contract, it's highest and best use in the respondent's sole and absolute.
Which is what you, is what you argued, although it's still, you can't just say that it's not the highest and best use to kind of keep them from coming in the door. You have to have a basis for that, right?
Your Honor, there's no question about it, and as
Well,
you.
one other thing, I'll accept without the end. Did you get the money from Exxon?
Your Honor, the terms of the payment are also confidential underneath the agreement, and
Is it
so,
confidential from the court?
Your Honor, I don't believe, without searching the record, and I think Justice Ostringer asked me a similar question.
Because it's sort of relevant to the court, and I don't know how you could keep it secret from the court. Do we
Your Honor,
have any confidential documents that have been filed with the court where you can tell me to go look at that for the answer?
I don't believe, Your Honor, there are any documents filed with respect to the payment.
So what did you tell Judge Ostrager?
I think when he asked me the question, he was gracious and not pressed, but the terms of the payment, I think there has been
You're
speculation.
not like me.
Well, no, very gracious, Your Honor, but the waterfall here is, Your Honor.
Can I go back to a question I asked opposing counsel? Do you agree that the property is zoned residential, commercial at this time, so that it could be developed either residentially or commercially?
Yes, Your Honor, I
So
don't
is the
believe.
only thing stopping it from being developed residentially the fact that you've leased it out to the supermarket?
Yes, there's an existing
That's the
tenant.
only thing that's preventing it from being developed residentially,
I
correct?
think, Your Honor, I would answer it, that's the only thing stopping it from beginning the process of developing it residentially. Once the building is removed, I can't speak to what other impediments there may
But right
be.
now, the only thing stopping it from being developed residentially is the fact that your client entered into a lease for the premises.
There's a tenant with a building and a lease, yes, Your Honor, that is the current impediment.
All right, thank you. Let's hear a rebuttal, please.
Your Honors, appellant waives rebuttal, and if there's any other questions, we rest on our brief.
Any questions? Thank you. Thank you
Thank you.
both. Thomas Rivera versus New York City Transit Authority. You may proceed.
Good afternoon. May it please the court. My name is Robert Drinan, and I appear today on behalf of the Transit Authority. The case law applicable to Article 75 review of voluntary arbitration awards.
We understand the standard of review. Is it true, though, and would you agree that the question here is, in looking at the arbitrator's award, was it irrational for the arbitrator to find that the circumstances presented by Mr. Thomas were not a substantiated, unforeseeable occurrence?
I'm sorry, Judge.
That's the key here. Should he have found that there was a substantiated, unforeseeable occurrence, or was it rational for him to find that there was not under the circumstances here?
Okay, thank you. My glasses are fogged up. I'm having a hard time seeing.
Right, we
this
all
is
have that problem with masks, right?
This is a quintessential issue of fact that is entirely within the purview of the arbitrator. Essentially, what the union is arguing is that as a matter of law, three forms from an urgent care place and testimony as a matter of law is sufficient to satisfy Rule 5 of the employer's rules to excuse these absences. And the arbitrator found that it wasn't. And there's a basis in there, and what he said was that Mr. Rivera hadn't shown that somebody else couldn't be there. He hadn't shown that his adult daughter needed 24-hour supervision, and he hadn't shown that he had to be there for 12 consecutive days. The underlying facts are very sympathetic, and every one of these arbitration awards is important. It's important to the union, it's important to transit and the employees. But the reason for the limited scope of review is that the parties pick the arbitrator. There's a level of trust and confidence in the arbitrator. And the parties can eject the arbitrator too, and they have in the past. And that's one of the reasons why the court almost always will not review the facts and not review the propriety of the penalty. That, in a nutshell, as you know, is our argument. I would like to comment very briefly on the preliminary award and the final award. The final award was issued after the petition was filed. Transit attached it to its answer. The answer was filed in March of 2021. The order, in this case, was issued more than 6 months later. The union had 6 months to alert Judge Nervo that there was a final award. They never complied with 7507 by serving a written demand on the arbitrator, and we would respectfully submit that any issue around that has been waived by not raising it in the lower court and by failing to comply with the CPLR. And we would respectfully request, therefore, that the order of the lower court be reversed and the arbitration award be confirmed. Thank you.
Thank you. You may proceed.
Oh, good afternoon, and special hello to Judge Scarpula and Judge Kern. I think it's ironic that I'm arguing an appeal of Judge Nervo's decision in front of you. It'll begin an asterisk when I write my life story. The court's right that the standard here is irrationality. And it's also important to note, just procedurally, that Judge Nervo, in his opinion, the document he refers to that he's reviewing is the award that was the initial award that was issued, not the one that post-dated the petition. He didn't consider that award.
I'm going to jump.
I can't hear you.
I'm going to jump right in and ask you a few questions because I looked at the form letters and I expected to see some content in them, but they simply said that the daughter could not go to work or school for a given period, and that period coincides, of course, with the time that the petitioner was out without being excused. I also searched the record to see if there was anything to indicate that the daughter, as counsel alluded to, needed supervision, that there was no one else available to take care of her. I mean, this is the facts.
Well, if,
Sympathetic
sorry.
in so many ways.
If,
Then when you come down to the record that was presented to the arbitrator, it's remiss and so much with respect to so much information that would have been perhaps dispositive here. What say you?
If the only evidence was the notes, the evidence was there was a series of notes from urgent care, and then he called in every day and explained, because the various notes that are in pages 49 through 56, that's a violation of 57.
Right, we're aware of the urgent care notes, right, we know they're in the record.
What those reflect, though, are that he called in that day, that he said daughter is sick, but he also testified, and the arbitrator said he testified credibly about the daughter's illness.
But
That's
he
in the
needed,
award.
He needed
The daughter
approval. He needed approval, counsel, in order to be out for the day or to be out for a given period of time. And there was one situation where I believe it was on 1/25/2020, when he was called by the depot. He said he would be in by 12 o'clock on February 7th, but he didn't show up until February 13th. So this creates a very difficult situation upon review, don't you think?
I don't think that's in the award, but it may be in the argument given by petitioner.
It's
or
one of the
appellant.
exhibits.
It was in an exhibit, but it wasn't. That's not anything that the arbitrator found. It's not discussed at all in the award. The exhibits are not. The findings, what we're arguing is the judge, the arbitrator, and I think the Phillips case, which I lost, is really the key here. The arbitrator made this finding, this finding, this finding, this finding. He was credible. She had bipolar disorder. She was told that she couldn't go to work or school. He felt that he had to stay home with her, but it wasn't
That's
unforeseen.
the issue that we want you to focus on. The fact that she was excused from going to work or school, which is all those records indicate, how does that create a nexus that he was unable to then attend work without something else?
Right, so he testified, and the arbitrator said he testified credibly, that's in the arbitrator's award, about what was going on with his daughter, and he called in every day to say, I have to stay home with my daughter. But it wasn't just that he handed in a bunch of notes. He testified at the arbitration. The arbitrator said that he testified credibly that he was concerned about his daughter and had to stay home with her because she was prohibited due to bipolar disorder and some other diagnosis from going to work or school, that he stayed home, he called in every day. To then conclude that wasn't an unforeseen circumstance is irrational. One could not, and he was not irresponsible. He was charged with abandonment of his job. He wasn't charged with violating a rule. He was charged with abandoning his job. Yet in the record, and what the arbitrator found, he called every day. He presented notes when he came back to work. He explained that his daughter was ill, but then he concluded that it was not an unforeseen circumstance. There's no rational connection between those findings. The arbitrator did, after we filed suit, he issued an award trying to explain how he got from the factual findings to his conclusion, but it was after we had already sued about it, and Judge Nervo did not consider that his subsequent explanation, which was inappropriate for him to offer.
All right, let's hear from your adversary on rebuttal.
Well, I think everybody in the arbitration room and everybody here is sympathetic with the facts. There's no question about it. And I think the arbitrator believed that his adult daughter really did suffer from the things that Mr. Rivera described.
Clearly, he did. He found the circumstances of Mr. Thomas, I believe he called them challenging, as it would be for any parent.
Absolutely, absolutely. You know, and the difficulty is when you look at unsubstantiated absences under Rule 5 and you look at the prior arbitration award, which required his dismissal, if there were the unexcused absences.
Right, and I think that the remedy, if the arbitrator's findings are sustained, is inescapable. But again, the question really comes down to whether, and it's also undisputed that he did not ask for prior approval. So the question is whether this is a substantiated, unforeseen circumstance. And the arbitrator said no, and the question is that rational? I mean, I think it's a narrow issue, right?
Agreed. And the scope of review is also very, very narrow, Judge, and thank you for your time.
Right, thank you. Thank you both. Building ABI Enterprises versus 711 Second Avenue.
Good afternoon, Your Honors. Michael Curran, attorney at law, Flushing, New York, for defendants, appellants, 711 Second Avenue Corp., and Ian Cheng. Your Honors, this is an appeal of the order and judgment modified April 27, 2020, and also the denial of a motion for a new trial on the basis of a missing witness and new evidence. We argue that it's an odd case. After 12 years of litigation, on February 2nd, 2022, respondents admitted that our clients never had possession of the subject premises in 711 Second Avenue. They admitted that the possession that was granted was in 707 Second Avenue. Now, Your Honors, I have a pictures in the record of the area, and I actually brought a better copy of those pictures, Your Honors, that are in the NICEF system. Unfortunately, the appendix doesn't have a really good quality photos, but it's the same photos. But in any event, I brought them if the court wants to see those. Basically, Your Honor, there were 3 buildings on the same deed. The deed was entered 12/31/1998 for 241 East 38th Street, 707 Second Avenue, also known as 243 38th Street, and 711 Second Avenue. 711 Second Avenue is a rather large building. In the record, you'll see there's a photo, and I think that's A794, and in that photo, you can see on the left side, 707 Second Avenue, which has about 3 windows in width, and 711, which is 6 windows in width. 707 had 1 storefront, a deli, which is currently occupied, and 711 had 3 storefronts and an entrance to apartments upstairs. My client was supposedly granted possession of 711 Second Avenue, but it wasn't until March 8th, 2019, at trial, when Exhibits E and F were admitted by the trial judge, that this whole thing was turned on its head. After trial, we saw that these exhibits did not match up with this alleged 711 Second Avenue possession. They show that there was possession granted in 707 Second Avenue. In fact, the exhibits are quite clear. One is a lease, that's Exhibit E, and that lease was inked over to say 707 Second Avenue, and the other was a letter of possession from Robert Rapuano, who gave this letter.
Didn't you have a copy of the lease?
We had a copy of the lease, but it was not the same.
Well, did you know that at trial? How could
No.
you only learn that? How could you only learn that at trial? Somebody's offering a lease into evidence, and it doesn't match your lease, and
Well,
you're confused by that. You don't speak up about that.
Well, Your Honor,
It's a little hard to
well,
understand.
it was a dimly lit courtroom, Your Honor, and
You're kidding, right?
no,
Is this dimly lit?
no, it's beautiful in here.
It is.
I love this
We
room.
agree.
I love
Okay.
the dome.
We agree. Go
In any
ahead.
event, Your Honor, what happened was we were never served the exhibits before trial. Counsel and we.
Did you get a chance to look at them when they were put into evidence, though? I mean,
Not really. It was
what
a very.
what does not really mean? I
it
mean,
was,
I
they
just
were
know.
they were not given to us, Your Honor.
They were marked, right?
They were marked.
And they were offered into evidence.
They were, but they
And then they
were
were with the clerk, right?
with the clerk.
And you could go to the clerk and say, hey, can I see that exhibit, lease
Your Honor,
exhibit?
if you look at those exhibits, they're not, Your Honor, there's 2 exhibits. One is the F, which is quite clear, and the other one is E, which is not clear. The inking over is very hard to see, but somebody, after the fact, went back and changed that lease. The lease.
I understand what you're saying. What I'm really questioning, because the whole purpose of a trial is that that's where you sort out your facts, and you're saying, gee, we didn't discover it at trial, when in fact it was a lease of which you otherwise had a copy because your client was a party to the lease, and wouldn't you look at it and say, this is not the lease that we had,
We had
Your Honor?
we had no chance or time to do that. We were not served those exhibits before trial, Your Honor. A289 in the record is the copy we had. We thought that they were identical. We didn't feel there was any need to examine a lease that we thought was identical with the one we had. We were snowed, Your Honor, at trial.
Okay, let's hear from your adversary.
Sure.
The lease in evidence was marked in the depositions several years earlier. The possession letter in evidence was marked at the depositions 7 years earlier.
Was
They
the
bear the
lease that was
marking.
marked at the deposition any different than the
No.
lease that, you have to wait for my question to be
Sorry.
finished. Any different than the lease that was offered into evidence?
No, they were the same documents. In fact, the lease in evidence bears both markings, the deposition marking and the trial marking. They knew about this issue many, many years ago.
That there was a handwritten interlineation on it.
Very clear, very clear. In any event, the tenant went to the premises with his architect, looked at it, and started the process of making an application to get approval for a restaurant. For one reason or another, he decided to abandon that process. And it wasn't because of the absence of a certificate of occupancy. If you'll note at page 11 of my brief, I point out that when the city responded to his application for a restaurant and said,
There was never
"Here's the
any, I read that. There's a process that you don't have a COO for buildings before 1938, right?
Right.
So that, I read that, I read what you presented at trial. I didn't get the sense that the tenant put up any rebuttal to that.
No, as a matter of fact, when we wrote to him and said, there's no C of O, he wrote back. You see at page 11, I quote the record, due to the change in the DOB, they're requiring more documents. He asked for 3 additional months to get it approved. He was not surprised.
You're talking about a no objection letter, counsel?
Pardon me, Your Honor?
You're talking about a no objection letter from DOB?
I'm sorry, Your Honor.
Is that justice? She's asking the question.
Yes, Your Honor.
You're referencing the no objection letter that could have been referenced by, that could have been issued by DOB?
Yes, yes, Your Honor, yes. Even if he was surprised that it didn't have a C of O, when we wrote to him and said it doesn't have a C of O, he didn't respond. He didn't know that. He wrote, I need a few more months of free rent. The lease had a 3-month rent concession, and he wanted an additional 3. And when he didn't get it, he walked away and claimed that he was defrauded. Now, his fraud claim is based upon the fact that we misrepresented that it could be used as a restaurant, knowing that it could not because it didn't have a C of O. But pre-38 restaurants, pre-38 buildings have restaurants. You just have to comply.
And the zoning allowed him to otherwise proceed with a restaurant that was in place, correct?
Yes.
Yeah.
Yes. In fact, there's restaurants were there before and restaurants have been there since. Now, something else. This matter was in civil court, and these arguments were presented to the civil court judge 4 times. She rejected the application to vacate. The civil court judgment has res judicata effect and bars all these defenses, but the defenses were of no merit anyway. The fraud claim has no merit because it's based upon the assumption that you can't have a restaurant in a pre-38 building. The claim of wrongful eviction has no merit. We always acknowledge that he had legal possession, but he never moved equipment in to take physical possession. And you can't be evicted when you're not there. So these claims had no merit, but they were barred by the doctrine of res judicata, and it's well-established law. I think they just had to come up with some defense, and this is what it is. The document, by the way, that a copy of the lease, not only was it not, it was never introduced into evidence. And he's relying on that for his argument that there was confusion as to the identity of the premises. But there's no testimony in the record as to any confusion. If the panel has no questions, I have nothing further to say.
Thank you. All right, we'll hear rebuttal.
Your Honor, the idea of the letter of no objection is a sound issue, except, excuse me, it never came up. The landlord never mentioned any use of this mechanism to get any approval. But, Your Honor, my client never had...
Is that in the record? There was testimony from the principal of the plaintiff about what was needed to be done in order to get the letter of no objection in a building where there was no C of O, such as this one.
Yes.
Right? And did your client get up and say, I didn't know of anything, I didn't know, nobody told me this?
Well, Your Honor, that witness also said he never did any letters of no objection for that building. He said he did them all over the city, but not in that building. It's in the testimony, Your Honor.
But what does that mean, though? Your client had an architect. It's easy to find out when buildings are
Well,
built.
Your Honor, he had no possession of any unit. If Your Honor looks at the facts,
He had no unit?
he had no unit.
Well, what unit did he think he had?
He thought he had a storefront, and he didn't know which one. But there were 3 storefronts in 711 Second Avenue. Excuse me, I'm sorry.
So that's.
I have a.
Did his architect draw plans?
His architect went into a unit.
Which one?
It was one of the units. We don't know. If you look at the rejection by the buildings department, it doesn't specify a unit. Buildings didn't even specify. It just basically said, my guy had to get a certificate of occupancy. Excuse me, I'm sorry, Your Honor.
That's okay. There's water. You have, I'm sorry?
Post-COVID. I'm not sick right now.
Okay, thank you for telling us.
I just had a long-term problem. Anyway, nobody ever offered to help my clients, Your Honor.
Counsel, please put your.
Yeah. Nobody ever said, the landlord has to be deeply involved with the letter of no objection. There's no way you can get that without the landlord helping you. Landlord never offered that. They just said, get out. They claimed they locked him out, but they didn't say which premises. If you look at the facts, not a single unit. Units in 711 Second Avenue were labeled ST1, ST2, ST3. Not one of those units appears on any lease or any
I'm
paper.
going to ask you one extra question, even though the red light is on.
I'm sorry.
I'm looking at the judgment from the civil court, which does say 711, doesn't it?
Yes. Not 707. We never got 707. We never got
711
711.
Second Avenue Corp.
Yes, it does say that, yeah, because he thought he was going to get that. He created a company because he thought he was going to get 711 Second Avenue, but he never got any premises. We didn't know all the facts until much later.
All right, we have your briefs. so
Yeah, I'm
thank
sorry,
you.
Your Honor. Sorry
Thank
for the
you.
coughing, I apologize.
So, well, all right. All right, thank you both.
Thank you.
People versus Pastrana.
Good afternoon, Your Honors. My name is Mark Zeno, and I represent appellant Pablo Pastrana. May it please the court. The people failed to establish both that the checkpoint stop leaving the Puerto Rican Day Parade was lawful, and even if the checkpoint was lawful, that the search of the closed, locked glove compartment of my client's car was lawful. The detective's bare testimony that a checkpoint had been set up to address vehicle safety is insufficient to show that the checkpoint was authorized for a valid purpose at NYPD's programmatic level. Here, by failing to show who had authorized the checkpoint.
Okay, Counsel, let's focus on the glove box, because that's, I mean, you know, I think that's the heart of the issue, the search of the glove box, right?
Sure. Well,
So
I think
the way I understand the testimony is that the officer pulls over the defendant's car. He smells marijuana. He looks in the car. He sees a twist on the floor. And then the officer testifies that when they get out, he gets a strong odor, a heavy odor of marijuana. So then he's thinking, and then he testified that the next thing he's going to do is going to look in the glove box, a locked glove box, which is in the interior of the car still. And that's where he finds the one plastic bag with a substantial amount of marijuana, and another plastic bag with firearm. Now, I think those facts are distinguishable from people versus, what's that?
Ponder.
Thank you. I got it written down somewhere. Do you think they're distinguishable facts?
Well, there is a factual distinction between a locked glove compartment and a trunk. That is a factual distinction.
That's a big distinction, because I think a lot of the cases are always talking about the trunk of the car. I mean, that's kind of extending beyond what the automobile I mean, it's kind of, the case law seems to say, you know, the trunk is a bit off, you know, not so much, you know, is suspect, you know, when you go that far.
Well, it was a locked glove compartment. The keys were in the car, he was driving. The question is whether there's probable cause to believe that there is marijuana in the glove compartment. I don't think it's distinguishable. In fact, if there's a distinction to be made, it weighs in my client's favor. My client didn't violate any traffic laws. He was merely leaving the Puerto Rican Day Parade, going home to the Bronx in his car, and
Why
he
should
stopped.
the law be any different, though, because it was, assuming that we find the checkpoint was valid, that it was a checkpoint versus an illegal, a stop for doing something illegal, because once the stop for valid reason, it's still the same analysis, isn't it, whether or not that search was proper or not?
Well, I don't think you can separate the checkpoint and the validity of a checkpoint. We make an exception to the
Once,
Constitution.
if we get past that point and we decide the checkpoint is valid, would the analysis differ in any way because he wasn't stopped for violating a traffic law versus that he was stopped based on a valid checkpoint?
Yes, it's an
How would
entire.
it be different?
It's an entirely suspicionless stop. There's nothing. He was doing nothing unlawful except returning home with his friends.
Does the law make a distinction between those two kind of stops?
I have not
In terms of
seen
the
any
analysis
case.
you do?
I have not seen any case law going either way on that issue, Your Honor. He was merely trying to go home from the Puerto Rican Day Parade. He had done nothing wrong. He was stopped. You've heard my argument about why that was.
Because we're all dancing around the same issue, and it's really the glove box versus a trunk. The trunk is ponder, right?
Correct.
Personal use marijuana, and that is essentially what the determination of probable cause really rests on here. Because the alcohol, it's not illegal to have alcohol in your car. It's not, astonishingly, nobody argues that it's illegal to have a boa constrictor around your neck in a car. You know, maybe it should be, I don't know. But those didn't seem to provide the basis for the probable cause. It was the personal use quantity of marijuana and the smell, right? But in Ponder, one of the things that the court was concerned about was the issue of nexus, you know, that these things alone didn't provide a nexus for finding personal use marijuana in the trunk. Could the same be said about a glove compartment? Isn't that kind of an area where somebody who is engaged in personal use of marijuana, which was illegal at the time, might keep a cigarette or two or a stash or two for personal use?
No,
you
you
can answer that.
Thank you, Judge.
Yeah.
This case is again, I'll return to it, is the facts are better for my client than Ponder, because in Ponder, the marijuana was found in a console, which belonged to the driver. My client was the driver. This personal use, single twist of marijuana was found at the feet of a passenger. It was not found in an area controlled by the driver. It was the possessor of the boa constrictor. So there's no reason to think that personal use quantity, tiny quantity in a single twist, you know, when someone exits the car, there's reason to believe there's contraband in a locked glove compartment. It's not like that person had access to the glove compartment. It was a locked glove compartment.
All right, thank you.
Good afternoon, ADA Nicole Neckles for the Office of Darcel D. Clark. Your Honor, there was probable cause for the search. Here,
All right, let me stop you. I mean, let's sort this out a little bit. Do you at least, or do you agree with the proposition that the open alcohol containers would not constitute probable cause to search the vehicle? There's nothing per se illegal about that.
I think we would say that there's nothing per se illegal about, but it is illegal to have open containers in the car. But
Based on what? You didn't have an inebriated driver, and in fact, your police officer, they testified he had no alcohol on his breath, he didn't seem inebriated, he didn't have bloodshot eyes, so that's really a non-issue, correct?
Correct, Your Honor.
And the boa constrictor, nobody's arguing that you can't have a boa constrictor in the car, right?
Correct.
Okay, so that really leads us to what do we have here? We have a very strong odor of marijuana.
Correct.
And we have a twist, or a golf ball.
It's a golf, right.
Yeah, which is, it really, sort of suggests that it's only personal use, and the cops don't really suggest otherwise.
Correct.
Why does that form a basis to go into the glove compartment, if any?
Your Honor, the officer testified, an experienced officer who had worked in Bronx narcotics, had been trained in detecting the smell of odor, that even after he recovered the marijuana on the floor, he continued to smell marijuana emanating from the car. It is reasonable, given that he had searched the other parts of the interior of the car, that that additional smell could have been coming from the console. Given that, I think it's reasonable for him to have reached in there and searched to see if additional sums were in there. Marijuana.
And he was only searching for marijuana at that point. He happened upon a gun, but that was happenstance, right?
That's correct.
And the counsel, at the time, I just want to make sure, even having a golf ball size stash of marijuana was illegal at that point. It wasn't decriminalized. It was still illegal.
At the time, this offense, I believe, occurred in 2015. So any amount of marijuana at that time was illegal.
So then how do you establish the nexus part? The search for the nexus for the area where he was searching. He couldn't search the trunk. Ponder tells us that, right?
Ponder tells us that the trunk, but the interior of the car, Your Honor, is vastly different from the trunk. And here,
How so?
I believe that as the court recognized, the glove compartment is certainly a reachable area in the car. That it was locked is I think not.
That's where he was smelling the smell, right? It was in the
Exactly.
interior of
He
the
said
car.
when he got to the passenger side, he continued he smelled a strong odor even after recovering the golf ball size of marijuana.
There's no indication that anybody was actually smoking.
That is correct, Your Honor, but unburnt marijuana does give off an odor.
That's what I'm saying, counsel.
So the fact that somebody wasn't presently smoking it certainly doesn't mean that it wasn't present in the car. And I think the judge properly credited the officer's testimony that he smelt the marijuana. And once that you have that credible testimony, the officer, the case law certainly suggests that the officer is permitted to conduct a search and look in areas that contraband could reasonably be located. And certainly marijuana, in terms of its size and shape, can reasonably be located in the glove compartment box. And we would say also, just briefly, the stop was also permissible, that the people presented sufficient evidence showing the reasonableness of the stop. The officer's testimony was sufficient. Detective Dietz testified regarding the fact that the purpose of the stop was for a security checkpoint to check the licenses and registration. He showed that it was operated in a non-discriminatory manner. There was an officer who was counting the cars, and an officer supervised to ensure that the checkpoint operated in a non-discriminatory manner. Therefore, the people presented sufficient evidence of the reasonableness and the propriety of the police conduct, and it was defendant's burden to show the unreasonable conduct. And defendant presented no evidence to undermine the people's evidence, and the court properly found that the stop was permissible.
Thank
We
you.
ask that the court affirm.
As you know, Your Honor, it's our position that the officer's claim that he smelled marijuana was incredible after removing the golf balls.
We should reject the credibility
I
determination
am
of the
saying
trial
that, Your
judge?
Honor. In fact, when the officer said a strong smell of marijuana, when we open up the glove compartment, there is marijuana in there, but it's packaged in Ziploc bags. There's no testimony that it was emanating any smell. So I just want to make it clear that I do not believe that that testimony was believable. I believe
It was actually more than just in Ziploc bags. It was Ziploc bags inside a Ziploc bag.
that's correct, Your Honor. There were multiple layers, and this was an anti-crime officer who was given this unusual assignment, those are his words, to stake out the bridge to the Bronx leaving the Puerto Rican Day Parade. And if you go to a surgeon for advice about what to do about a condition, they want to do surgery. If you go to put an anti-crime officer who's charged with looking for guns at a checkpoint, leaving the Puerto Rican Day Parade, he's going to look for guns. And that's our position, Your Honor. And even putting aside credibility, the fact that there may have been a residual smell of marijuana in the area of the locked glove box where the marijuana was recovered from the floor in a twist, not a hermetically sealed Ziploc bag within a Ziploc bag, as the facts show, was in the glove compartment. That does not give probable cause. That sniff of marijuana does not give probable cause to believe there's something in the locked glove box. Thank you.
Thank you both. Ms. Boley versus Board of Trustees. You may proceed.
Good afternoon, Your Honors. Dina Kolker, Strucken-Levan for petitioners, appellants. The central question in the case before you today is whether a mere change in title permits the pension system respondent to strip petitioners and other similarly situated employees of their tier status and the application straightforwardly of several provisions of the Retirement and Social Security law. To be clear, the case is not about plans or pension benefit calculations. It asks a threshold question of what tier should these petitioners be in, because...
So, counsel, if I may interrupt. So your basic argument is that the tier is portable, that when a person leaves city service, for example, in agency A, and they move to agency B, their tier travels with them, it transfers. I looked, but the only thing that I found was that the eligibility to continue in the retirement plan exists, but not necessarily the tier. Now, I'm very troubled by the fact that there's no notice given to continuing employees, for lack of a better term, that their tier can be affected by changing employment within the city. Is there a notice requirement somewhere? Because I haven't seen it, and I don't know that it exists in any collective bargaining agreement, for example. But what about this notion of the transferability of tiers, portability? I'm going to change that word, portability.
Right. So what the non-impairment clause and several provisions in the Retirement and Social Security law make clear is that the date of initial entry into a pension system is a critical date at which those contract rights are established. Not only is that defined by the non-impairment clause in the cases interpreting it that talk about the importance of the initial entry date, but the reinstatement and transfer provisions of the Retirement and Social Security law, which predate Tier 6 and which continued in full force, were not amended, also support the importance of the original entry
Counsel,
date.
I have a question. The petitioners here, were any of them sanitation employees at the time when they left the system? Because they came back and became sanitation employees, right?
No, not all of them, Your Honor. The petitioners fall into three categories. The
Right.
first are city employees who were members of NYSERS and merely changed titles.
Yes.
There
But none
are,
of them were sanitation workers, though.
they were not sanitation workers. They had other city titles
That's
within
what I
city
asked.
employment.
That's the question I asked. Were any of the petitioners sanitation employees when they left the system? I understand that when you leave the system, you come back. You start back.
I understand.
It depends on where you. It depends on where you leave and where you come back. If you left as sanitation workers and you came back as sanitation workers, clearly then it's the title that, or it was the tier that you left in, right? You continue that service. But if you weren't sanitation workers when you left and you come back as sanitation workers, it's a little bit different.
I think I would just like to talk about the term leaving and coming back, because I don't think there was any leaving and coming back for some of the petitioners.
Okay, fair enough.
They-
Nobody left. Let's just say nobody left. But in terms of the
Right.
title, in terms of tier 6 that we're talking about here,
Correct.
that was specifically crafted for addressing sanitation employees.
It was not, Your Honor.
Oh.
That is the impression being created by respondents. Tier 6 was a major overhaul of the entire pension system that created new Tier 6 benefits for civilian titles,
Doesn't it
uniform titles.
specifically say that if you come in to become a sanitation worker after that change, 2012, then you go into the Tier 6 plan, if you become a sanitation worker after that date? It doesn't say anything about what you're arguing, that if you were in another title before, that comes over with you. The law is pretty unambiguous in saying that if you become a sanitation worker after 2012, you're Tier 6. So how do you get around that?
Respectfully, Your Honor, the provision of 501, Section 25, which is I think what you're referring to, doesn't actually say if you become a sanitation worker after April 1st, 2012. What it says is if you become subject to Article 14 on or after April 1st, 2012, and you are a sanitation worker, then you are in the revised sanitation worker plan.
Why wouldn't that apply to all of the?
They did not become
petitioners in this
subject
case?
to Article 14. These were individuals who were already subject to Article 15
Well,
and
that's a
who did
different
not
article,
meet.
though.
I'm
But
sorry?
That's a different article. They weren't subject to 14 until they became sanitation workers after 2012. They were previously in the retirement system. One had withdrawn, but they were previously in the retirement system under a different article, weren't they?
They were, but that article also includes sanitation workers and also has a sanitation worker title-specific plan. The Tier 4 sanitation plan is contained in Article 15, and the provisions for that plan indicate that if you are subject to Article 15 and later become a sanitation worker, you fall into the SA-20 plan.
So,
That is
counsel,
what
are you saying-
604-A
Counsel?
provides.
All right, Article 15 says that it doesn't apply to members of the uniformed force who join or rejoin on or after April 12. You're saying all your plaintiffs joined before April 12?
Yes.
Joined sanitation
But
before April 12. That's what I'm asking you. Because if they didn't, then Article 15 does not apply to them, right?
I would just continue reading the section you're focusing on.
Yeah.
Join or rejoin a public retirement system of the state on or after April 1st, 2012. It does not say in section 600A6, join or rejoin the sanitation force. Those who remained in the employ of the city remained as NYSERS members before and after becoming sanitation workers, by no definition have joined or rejoined a pension system of the state. And those who transferred and reinstated are deemed under Section 43 and Section 645 respectively to not have joined or rejoined because they are deemed to have always been members of the pension system to which they either transferred or to which they rejoined. And within Article 15, there is an appropriate, available, title-specific sanitation plan, the SA-20 plan, Tier 4 plan, which is exactly where these
So
individuals were
how
placed
do
to begin with.
you, let me interrupt you for just 1 second, please. And how do you square the legislative history that says uniformed sanitation members who were not sanitation members before April 12, 2000, to before April 1, 2012, would be given the modified Tier 3, right? That's what the legislative history says, that uniformed sanitation members who were not sanitation members before April 1, 2012. Are any of your plaintiffs sanitation members before 2012?
They were not, Your Honor.
So then
I'm
the
not sure.
legislative history for the bill says they would, those people who come after April 1st would be given the modified Tier 3 police fire benefits provided in SA 22.
If I could just answer that, I'm not sure what page of the legislative history
I'm
you are
looking at
referring
the
to.
bill jacket at 18, at page 2.
The bill jacket is.
Chapter 18, page 2. I mean, that's what the legislative history says.
I'm trying to find that in the record, Your Honor. I'm
Okay.
sorry. Do you know
Anyway,
the page in the record?
Let's assume that that's what it says.
Okay, well, I'm not familiar with that language in the legislative history, but if you look at the introducer's memorandum, for example, which is in the record pages 57 and 58,
Right.
the provision, the section that starts summary of provisions specifically says the following bill sections, including a description of the one for sanitation workers, would impact members who first become members of the various pension systems on or after April 1st, 2012. That's the preamble to that entire part of the introducer's memorandum, including the section specifically talking about sanitation workers. And that language is consistent with the language in Section 600, which only excludes from Article 15 those who join or rejoin a public pension system, not the sanitation workforce. And so the reference in the later section on page 58 of the record to, quote, new sanitation workers is defined by the preamble to that entire part of the memo, which says this applies just to people who join or rejoin the pension system.
You'll have some time on rebuttal. Thank you. Let's hear from your adversary.
Good afternoon. May it please the court, Lorenzo De Silvio on behalf of NICERS. With the court's permission, I'd like to jump right in to the last question, because it is the case that the legislative history, I believe it's at page 57 of the record, forecloses the argument that petitioners advance, which is so long as you were in a public retirement system in the state before the effective date of the legislation, that means you keep your Tier 4 status. Because the legislative history that you just quoted specifically addresses that. Moreover, subsection 25 of 501 of the RSSL says you have to be a member of a public retirement system of the state who becomes subject to Article 14. So the idea that those two things collapse into one another is just belied by that statutory construction.
So are you saying there are two separate requirements, right?
So our brief says that there's three.
Three.
You have to be a member of a public retirement system who becomes subject to Article 14 on or after the trigger date of the amendments here, and who satisfies an additional criterion or criteria that is specific to each of the 5 covered titles that the legislature was amending starting in April 2012. So for instance, for police and fire members, you have to join the actual fund. For sanitation workers like corrections officers, you have to join the title, the uniform title at DSNY or DOC if you're corrections officers, and that's the event that makes one subject to Article 14, as your Honor's questions indicated. I'd like to make 2 additional...
So, counsel,
yes,
let
Your
me
Honor.
just ask you, is that, this is the first time I've ever heard of an employee switching from one agency to another and having to go from a different tier. Is that, are these titles the only titles that happens in?
So I think it happens with corrections officers and sanitation workers because that's what the legislature did in 2012 with respect to those. And I understand your question to be sort of asking an equitable one, but
Right.
it's the case that when there is pension reform in this state, there is by necessity less generous benefits provided to subsequent tiers. And there's no dispute that that could be, new to employment, but here it's new to an agency.
So
and
that's my question to you. If I go into the system and I think I'm going to be in tier 4, and then I become from one city agency to another city agency, I lose my benefits and I'm not told for 2 years. What's the remedy for that?
To correct you, and this doesn't help my case, it was 4 years because.
4 years, okay, that's even worse.
I just
What's
wanted
the
to be
remedy for
upfront
that?
with the court.
I understand. The city says, oops, my bad. But then you have people who have spent 4 years not getting benefits they think they're entitled to. So what's the remedy for that?
So I want to address a subpoint implicit in your question, Your Honor, because petitioners advance the argument that we are pulling out the rug from under them and putting them in a less generous plan, but that's not accurate. If you compare page 52 to page 54 of the record, and that describes SA 20 versus SA 22, you have to make additional member contributions if you're in SA 20. You don't have to make an SA 22. And the irony of petitioners' argument that it's actually NICERs who are stripping them of their original entry date is that under SA 20, only credited service is allowed. There's at least 3 petitioners. One was a paraprofessional, one was a bus driver, one was, I believe, a developmental aide, who were not in uniform titles before they came to DSNY. And under SA 20, which petitioners want everybody to be in, all of that time doesn't count. Whereas under NICER's interpretation, 43 and 645 apply equally to petitioners, and it's just not the case that we're reading them out of the statutory case.
So you're saying some of them are actually getting a better benefit because they're getting time that they would not otherwise get if they just went straight into sanitation?
That's correct, all of the time.
And the downside is that they need to work a little longer instead of SA 20 versus SA 22. We're talking 2 years, right? I mean, that's the downside.
20 all at sanitation for some petitioners, or 22, including all of the time that they had before.
And the other thing about switching employments, I mean, you can come in as tier 4, and if you happen to switch employment or positions to another position that's tier 4, nothing's going to really change, right? I mean, that's what happens. But if you change position, you go into another title that's covered by statute. That's the way the statute reads. I know you said 4 years, but there's no estoppel against the pension fund from correcting mistakes.
That's correct. Yes, Justice Oing. And the petitioners have not cited any case where, under the facts of this case, a retirement system has been stopped when it has to by law.
I mean, the ramifications are incredible if there is an estoppel effect against the pension fund.
That's correct.
But counsel, it is absolutely astounding that people would change jobs within be it the city retirement system or we're talking about city, and be absolutely in the dark as to what the ramifications were on their retirement.
Your Honor, I totally understand the equities of your question, but it's just the case that because of the premium put on the protecting the public fisc and ensuring the financial soundness of the pension systems, that when this does happen, we cite a case where someone was told your military credit will count, but then it turns out it didn't, and I believe that person had to come back to work. There can be an equitable result sometime, but they are in service of the integrity of all of the financial systems. But I certainly understand what Your Honor is saying. I'd like to make just one last point about sections 43 and 645. There's nothing in either of those statutes that says you get to keep your tier status. Rather, it refers to credit. And there's actually a subsection of 43, subsection J, which says if you were vested in the first system, but not in the second, you can actually be vested in the second system under the rules of the first, which underscores that the legislature, when it wanted to, specified you get to carry your rights from the first system, and it did so with vesting, but it didn't say anything about tier status in any of the statutes.
With respect to Petitioner O's, I think that's how you say his name, he becomes a sanitation worker 2 years after the trigger date, right? 2014 instead of 2012. And he's told he's eligible for reinstatements if he repays the money that he was paid when his prior membership was terminated, because he worked until 2008, but then returns in 2014 from the police department to the sanitation department. So he switches,
That credit would
he
count.
switches departments. But what you're saying is that the money goes to restoring his status as what? With his years of credit as opposed to his tier?
So the years of credit will count for that particular petitioner because he was in a uniform title beforehand. But otherwise, he has to be an SA 22 because of the language in subsection 25.
But the 22 years that he's required in order to qualify for the pension, he otherwise gets credit for the time that he was in a different tier.
That's correct.
And that is what he recoups by paying back that money.
And yes, and that will be true for everyone in SA 22. And NYSERS has letters telling each of the petitioners, we'll pay you back the money with interest, so they will be restored to the status quo ante. Thank you very much.
Okay. All right, rebuttal?
Your Honors, to answer a couple of the questions that came up, they don't apply this rule to the other titles. They allow them to reinstate and transfer and maintain their original entry date. And that includes other titles that also have title-driven specific plans, not the sanitation plan, but others.
So this is just limited to the sanitation workers and the court officers?
Correctional officers. NYSERS is limiting it to the sanitation workers and correction officers, and we submit there's no basis in the law to deny them the benefit of Section 43 and 6 and the reinstatement provision either. The notion that the transfer provision and the reinstatement provision are not about maintaining your original entry date are simply not true. The reinstatement provision in particular, I believe in the Lynch case, was described by the court as the purpose being to reinstate your tier. Whatever plan your new title qualifies you for within that tier is the plan. We're not attempting to maintain civilian benefits in a sanitation plan. The point is that you get the benefit of your original entry date, which determines your tier, and then whatever applicable, appropriate plan there is within your tier. And here, that's the SA-20 plan. The major difference between the SA-20 and SA-22 plans is not just the 2 years of service and the distinction in what service counts. These petitioners were advised that their civilian service would not count, and they still wanted to be in Tier 4 and in the SA-20 plan because, importantly, the SA-20 plan does not have a Social Security offset, which would serve to reduce your benefit down the road when you began receiving Social Security benefits. The Tier 6 SA-22 plan does, and that is viewed as a major disadvantage of the SA-22 plan. I also want to go back to this notion of collapsing separate provisions under 501.25. Whether you read that section as having 3 components or 2 components as we do, the 2 individual components are becoming subject to Article 14 as of a certain date and separately being a sanitation worker. Had the legislature wanted to say anyone who is appointed as a sanitation worker after April 1st, 2012, they could have easily said that. It doesn't say that. It says you become subject to Article 14. The question here is, how do you become subject to Article 14? If it is the same as becoming a sanitation worker, then you've made the second part of that requirement under 501.25 superfluous. You've also made the language in 600 saying that the only people excluded from Article 15 are those sanitation workers who join or rejoin a pension system after April 1st, 2012. You've made that superfluous. Because anybody who becomes a sanitation worker after April 1st, 2012, according to NYSERS, would have to be in the Tier 6 plan. So that's 2 sections already that have been made superfluous, not to mention the application of the transfer provision and the reinstatement provision, which would also become inapplicable without any statement for the legislature as to why or how to sanitation workers. It's 2 distinct requirements. These employees have never become subject to Article 14. And if you'll give me 1 second just to address, because I know it's in the papers, the cases out of the second department.
I'm not. I've already let you go
Thank
over
you.
your time, but thank you.
Thank you.
All right. Levin versus Levin. I can't wait till you're in the middle. Not me. Okay, you can proceed.
Thank you, Your Honor. May it please the court, my name is Kevin McDonough. I represent the plaintiff Matthew Levin in connection with this matrimonial action. Before I go any further, we are well aware of the oft-stated rule that the remedy to fix a pendente lite order is a speedy trial. But in this case, there are a number of problems with that. One, our client simply does not have the financial wherewithal to make these payments on an interim basis. The case has been significantly delayed because of COVID and otherwise. But more importantly, in this case, we believe that there's a clear legal error in the court's pendente lite order. In this case, the court issued an order which contains a double shelter allowance, which is impermissible under the law. Part of basic child support awards are to provide for the food, shelter, clothing, etc. of the minor children of the marriage.
Is there any discussion at all below of whether there should or should not be an award for carrying costs as part of the pendente lite award?
And so the respondent wife made a motion in the order to show cause. She sought a specific amount of child support. There was no reference in her application for anything having to do with housing costs. We were paying $6,000 a month. She asked for $8,700 of child support. The $6,000 a month was our contribution to the housing costs, which is actually in excess of the statutory child support amount. We cross-moved and we asked the court to do one of two things. Either confirm our voluntary payments, which we felt were in excess of what our legal obligations were, the $6,000 a month towards the housing, or set a basic child support amount payable to the wife of $4,000,
You were
and
suggesting
she would.
to the court that they should only award carrying costs and not award any child support?
I missed the first thing you said.
You were suggesting to the court that they only award carrying costs and make no award for child support?
Correct, either or. Either child support of $4,000 or what the status quo was of us paying housing of $6,000 per month.
Let me just, I'm sorry, I just want to interrupt to make sure that I understand. This was a rental apartment?
No,
They own it.
correct.
So it was an asset that they were trying to preserve as well as otherwise provide shelter?
I don't know, I'm not sure I understand what an asset they were trying to preserve.
There hadn't been equitable distribution, so presumably
Correct.
this was an asset that was available for equitable distribution.
Correct.
And if you didn't preserve it, then I don't know what would happen.
Correct,
Yeah.
but it was being preserved. He was paying the lion's share of the expenses
But don't the
associated.
children have to eat?
Yes, but the mother's making $500,000 a year in
I
her,
understand that.
and that was.
So, but what kind of offer is it to say, I'll just maintain that house? I mean, I don't really understand. You have to make an award, even pendente lite, unless you're going to deviate, you have to sort of go by the strictures of the CSSA, no?
Correct, and the court could have made the award of child support because child support encompasses housing. The
Counsel,
court,
did you put forth a figure, I'm just trying to figure out how the court got to where it was. Did you put forth a figure to the trial court of what the total amount of income should be for Child Support Standards Act, since there's an ability to go upwards of the statutory amount? Did you argue any specific number as to what the number should be used?
our cap, what we proposed as a cap for the child support, yes, $350,000, and that's how the $400,000 came about. But to come back to your question, Justice Kern, the court, in its recitation of the facts, made an error. The court stated that we proposed that we would pay $4,000 a month of child support plus continued to pay the $6,000. That was just an error that the court made in terms of what our cross motion said. That's not what our cross motion said. She asked for basic child support of $8,700. We said either continue this, which was what the status quo was, not only during the year plus pendency of the divorce case before she made this motion, but before there was even a divorce pending, which was the status quo. We offered to continue that,
Maybe that explains why she didn't have any analysis in her decision of why carrying costs are being imposed in addition to the child support.
So I believe that the lower court made an error in reading the papers, and perhaps that is, then leads to the failure to comply with the Child Support Standards Act. I mean, you can only order a double shelter.
Is it a failure? I mean, is it a failure to comply with the Child Support Standards Act, or is it a failure that just there was a double shelter allowance?
I think it's both. If you're going to award basic child support and the shelter allowance, you have to find that the child support amount under the statute, and the court says, I am applying the statutory formula using these amounts, and comes up with the $4,750. If the court wanted to go beyond that amount, that for some reason, and the respondent cites very, very, very high asset and income cases where courts have done that. If the lower court wanted to do that and was intending to do that, the court would have had to say, this is my finding of the basic child support amount. I find it's unjust and inappropriate, and therefore I'm going to deviate and direct all the additional payments of $6,000 on top of the child support amount, which was more than the wife even asked for. And if you go and look, it is clear that that's not what she asked for. If you look at her net worth statement and the expenses that are set forth in that, there's no question. When she asked for the child support amount of $8,750, she was including the housing amounts in her request. Thank you.
Okay, thank you.
Good afternoon, Your Honors. I'm Matthew Keston. I'm representing the...
I'm sorry. You could finish introducing.
Matthew Keston. My firm is representing the respondent. There was a question, obviously.
I'm just wondering what your response is to that the court, in effect, awarded more than the amount that was requested, and there was no discussion in the decision about why the court was awarding carrying costs over and above the Child Support Standards Act analysis of child support.
Well, again, I've seen this in other cases. There was that catch-all in the order to show cause that was filed asking for any further and other relief that the court thinks is just and proper. Obviously, the court took into consideration the fact that the husband had been
Doesn't a court then have to give, if the court's going to do that, and the court has broad authority to do whatever it wishes, doesn't it have to give an explanation of why it is doing that, why it's ordering a double shelter allowance in effect, and why it's ordering more than was even requested? And does this decision do that?
I would be hard-pressed in the confines of this courtroom to say that Judge Sattler didn't dot all her I's and cross all her T's. The issue on the double shelter allowance is easily correctable, as we have in our papers, and counsel didn't even respond to it in their reply. All you have to do, and this is a number of appellate divisions cases all say the same thing. Second department, correct. I haven't found the first, but other departments have said the same thing too. You simply take the housing costs, you subtract it from the husband's income, and you redo the calculations.
Which income would we subtract it from?
Exactly the 2019 income that Judge Sattler used, because that was the income reported on the last tax return, which was the proper income to use. She also ascribed additional...
If we did that, wouldn't you still be getting more than what you requested in the Pendente Lite order?
Probably. And again,
well,
that's
if we did that, how does that remedy the fact that she didn't give any analysis for why she was awarding significantly more than what was ever requested?
That one I can't answer other than the catch-all that's in the order to show cause, which I've seen in other cases. She thought it was appropriate because this was a children's home, obviously. Again, this is all speculation because there's no analysis.
Do you concede that you were never asking for carrying costs? You were just asking for a larger amount of child support?
Well, that's obviously what she was thinking of. My client would have certainly bumped up the number to more. The judge would have bumped up the child support number more if she was pulling out the housing costs.
But to get to the number that she got to, which is the 4,400 plus over 7,000, she would have to have a very big cap.
Yeah, I think the cap would have been closer to about 600, again, which is still within the court's discretion to do something. She could have looked at 100% of the combined income. It's all discretionary over the top, and I do agree.
She'd have to be explaining her basis for doing
Yeah, I can't argue that she shouldn't have put more explanation into the decision. I think it's clear what she was trying to do. And again, if she didn't dot all her I's and cross all her T's, I think the court can easily remedy that. You simply keep the housing costs in effect. You reduce the child support. It ends up coming to $4,500 instead of $4,750. 50. I have it in our brief. I did the calculations for the court on the same numbers that she was using. And, again, I don't think we're really arguing about the numbers that she was using because by statute, you had to use the last full year's tax return. She did that, not subsequent years, which was what counsel was arguing. She should look at other years. So she did that right. She just didn't dot our I's and cross all our T's. 2019 was correct. I know it wasn't addressed in argument. They were also talking about the arrears, too. I mean, it's statutory. She has to make it retroactive. The one glitch I'll say that she didn't include in there, which is statutory, too, is the husband's entitled to get a credit for any voluntary payments. Saying that there are no arrears, though, without having a hearing, proof of payment, that's not what happens. The usual decisions, and Judge Gish, you were in the matrimonial part. You'd write a decision that said retroactive to the date of application, minus any credits that they're entitled to. There's no determination there of what the credits actually are. That comes later because the court isn't provided with proof of all the payments.
I don't understand. Do you agree that the case should be sent back to the court?
I'm sorry, I didn't hear what you said.
Do you agree that the case should be sent back to the lower court?
Absolutely not. As I put in our brief, I think this court can remedy the double shelter problem. The other issues aren't issues that have to go back. Judge Sattler properly made the award retroactive to the date of the application, which is statutory. She correctly used the 2019 returns. She correctly imputed some income to the husband who threw off some W-2 income, some phantom W-2 income to his wife for tax purposes. She put that back onto his income correctly, and then she ran the numbers. And all I think this court has to do is what all the other appellate divisions, yes, I didn't find a First Department case that said the same thing. You just do the math again. Rather than spending another 6 or 8 months going through a remand and going back to the court, you simply redo the numbers, as many courts have done. I've cited a number of courts that have done the calculation.
So in redoing the numbers, and in this case, is somewhat unique in that the carrying costs that the husband is paying on the shelter is not the full amount. So if you credit that back, does the wife have to be credited in terms of her income and a recalculation of child support because of that, or you're
not on this number at all. The credits come later on. That's only with respect to arrears, not the going forward.
No. I'm not talking about that. But the court figured out, based on the relative incomes, what the proper percentages are for the parties to pay for add-ons, right?
She did I think it was 57-43.
Right. And part of what you're talking about is changing those numbers because of the payment of the carrying costs. Do the same adjustments have to be made on the other end to your client? And do we have to recalculate child support in total?
I think you have to do a recalculation of the child support number, and when you do that, when you give the husband the credit for the payments he's making, I don't think you have to give the wife the credit on the numbers that she's paying. It's like if she was paying rent for an apartment, you wouldn't take that out, and you wouldn't say that comes off the top from her income. I see my time was up. If anyone has any questions, I'd be happy to answer.
I have one question. I just want to make sure that your solution, your proposed solution is get rid of the housing allowance and recalculate the child support allowance. Is that what you're suggesting?
I wouldn't say it that way. What I would say is take the amount on a prospective basis the husband will be paying for housing costs. You subtract that from his income. Instead of his income being
on a yearly basis, and then recalculate.
Correct. Instead of his income being like $650, it would be $650 minus $72,000. And then you just do the numbers. And when I redid the numbers, it came out to $4,500 a month for basic child support with the same contributions to housing, which is a marital asset.
And the number that you used, and you said which tax return you got it from, was the number that Judge Sattler figured in adding back that phantom money that was theoretically paid by the husband's business for bookkeeping that was never paid.
Well, I don't know if it was bookkeeping or what. All I know there was a phantom W-2 and my client was not an employee of the business. I'm assuming it was for tax purposes so that they could take a deduction, and that's why Judge Sattler put it back onto the income.
She added it back in. Yeah, okay.
Okay, thank you, Your Honors.
So,
Counsel, let me just, I'm sorry, go ahead. I just want to ask you whether you agree that that recalculation would resolve the issue of the double payment.
No, because then it goes into what child support income, total income cap you use, and so that's not a solution. And one of the justices also asked, what income do you use? So when it's recalculated, the 2020 income was in the record. Judge Sattler did not address that income. His income, every 1099, without regard to these issues of add backs and the salary for the wife, his gross revenue for 2020, so I'm not taking a dollar as a deduction for business expenses, was $485,000, which was what was consistent throughout the marriage. Hers was $495,000, which is why we had proposed 50-50 on the add-ons. So there's a whole host of other issues in terms of when that recalculation is done, and it's done properly without double counting on the shelter. The number is very different. They want.
So, I mean, this is consistent with what my colleague is asking you. So how would you calculate it without it going back to the court for a redo? How could you account for suppose we agreed with you, there's a double shelter. How do we account for that?
If you take the $400,000 income cap, use his income of $485,000, her income of $495,000, and that's about 50-50. So on a $400,000 income, the child support is $100,000. His 50% is $4,250 a month, which is right in line.
But why are we doing that? Your claim is that there's a problem because we have directed 2 elements of shelter.
Right.
So what component of the basic child support award is attributable to shelter that we should make some offset there? How do we figure that?
Well, I don't know that the courts ever specifically say, this is the basic child support number, it's $5,000, right, based upon your income. And I'm going to say, of that $5,000, $1,650 is attributable to housing, and $700 is food, and $800 is, the courts don't break it down that way. It's based upon the income. Here's the child support amount, which is payable to the custodial parent, and that's the end of it. There is no shelter allowance. There's no shelter allowance under the statute. There's basic child support, and then you have add-ons. So she gets an amount of money for child support, which goes to expenses, which include the children's. And again, if I could bring you back to her net worth statement in particular, there's no question that when she asked for $87.50 a month of child support, that included a portion of the housing for the children, because the children's other expenses for food, for clothing, are not significant. There's no way you get
Counsel,
to.
let me just ask you, are you suggesting that we just strike the award for housing and leave the
Yes.
child support?
Yes.
And that's what you're saying is the appropriate solution?
Yes.
Okay.
Yes.
Okay.
We could debate the cap. That's at the $400,000 cap that Judge Sattler used for the income.
Right.
I said 300. They asked for 600. That's a
Got it.
debatable point.
Okay, thank you. Thank you both. $862 Second Avenue against 2 DAG Hammersgold Plaza.
Good afternoon, Your Honors. My name is Peter Molinos. I represent the Board of Managers of the 2 DAG Hammershow Plaza condominium. And we bring before you an appeal that sets forth a very novel issue that's basically a first impression. The question before this court...
Maybe second impression? We already
Maybe second
decided
impression.
it. But it is a unique issue. I'll give you that. It's
It
very
is.
unusual.
You need to go back to 1972 when the original case of Newport Associates versus Solo was decided.
Counsel, my colleague already intimated, why aren't we bound by the prior decision in this case where we clearly talked about this same exact issue and came to conclusion supporting the trial judge's initial determinations issue? Why should you get a second bite of the apple now? Why isn't our prior decision law of the case that binds us in terms of how to decide this issue?
3 reasons why the law of the case should not bind this court. The first one is because the issue of the reversion of the development rights was never before the court previously. The sole issue that was before the court was whether or not the respondent was entitled to use and occupancy pending the outcome of the action.
But wasn't the argument made before us that the reason that no use and occupancy should be paid is because your client owned those rights?
Not exactly. The argument was made that use and occupancy should not be paid on the air rights because our client owned the rights.
Counsel,
However,
I'm going to read the exact language, and you tell me how we didn't decide this. The court also properly rejected DAG's argument that any award for use and occupancy cannot include rental amounts related to plaintiff's lease of its development rights, as well as DAG's unsupported claim that it obtained ownership of such rights upon termination of the lease. So that second part of the sentence, that seems like a pretty clear pronunciation by the First Department that your claim that you obtained ownership rights upon the termination of the lease is unsupported.
well, not exactly, because the merits of the reversion were never raised in the underlying decision, nor before this appellate division. So what was at issue was the ownership. What we have now is the respondent.
Didn't you raise it in the prior application when, as a defense to the use and occupancy?
Yes, we
That
did,
you
Your
didn't
Honor.
have to pay the use and occupancy because you had ownership rights?
Yes, Your Honor. But the
And
issue.
wasn't that rejected by both the trial court and the First Department in the use and occupancy determination?
Yes, Your Honor, but the issue was never fully and fairly litigated. For example, and that's a requirement for the law of the case doctrine to apply, because our affirmative defense of statute of frauds was never brought forth. And that affirmative defense can only be brought forth as part of a.
Well, how could there be a statute of frauds defense where the lease is the writing? It's the two leases that are the writings that are the whole basis for deciding the issue of whether or not you had any ownership rights upon termination of the lease. So how could there be a statute of frauds defense?
Again, because that's only for the purpose of this use and occupancy order. It doesn't provide as to what happens for the reversion after the lease is terminated.
Well, all right, so let's get to the merits. I don't know if we agree with you about law of the case, but even on the merits, why isn't it appropriate to enforce the lease according to what it says, which says that it reverts back?
Because the lease only says that the demise premises reverts back. It never mentions the air rights. And I believe my adversary agrees that the lease is defined as the demise premises, which is what reverts back. And the Solo case provides that in order for someone to be able to obtain the ownership of the development rights, they need to show that first there was a lease of more than 75 years, which the lower court also was erroneous on. They assumed it was for 55 years. We need to show that we were the first ones that used those rights, which I don't believe there's any dispute. And again, everyone agrees that we were the first to use those rights. But there also needs to be a reservation of those air rights in the lease, and that does not exist. And as Judge Gish mentions, we should look at the lease, because the lease basically ignores what happens to the development rights after termination. Interestingly enough, what it does provide.
To have a separate contract then, or have some language in the lease? You're asking us to create something that's not there, counsel.
Exactly, Judge Gonzalez, because exactly what the Solo case said was plaintiff's mischance is that they not include a reversion clause in the lease.
Counsel, isn't Solo distinguishable though? Because in Solo, they didn't really talk about the development rights. But here, the 1966 lease expressly reserves development rights to plaintiff's predecessor, and those terms were incorporated into the 1968 lease. So doesn't that fact distinguish this case from Solo, where there was no discussion of this issue?
Absolutely not, because the 66 lease only reserved the unused portion of the development rights. At the time the parties entered into this lease, they knew that my client's predecessor in interest was going to construct a condo building. And what did they do? They specifically put a clause in the existing lease that said that the landlord reserves the unused development rights. They could have said that when the lease terminates, the development rights revert back, as the used development rights revert back to the landlord. They never said that. So as Judge Gish says, if we look at the lease, all these material facts
Wait a second,
are missing.
counsel, doesn't the 1966 lease expressly say that?
Expressly states that the landlord reserves the unused development rights, those development rights not used to construct the building. It never says that there's a reservation of the development rights that are going to be used to
Counsel,
construct the
but
building.
why wouldn't he say that when the demise premises, doesn't the demise premises include the development rights that were actually used in?
Absolutely not. It doesn't say that. And why
I
would the
know it
parties?
doesn't say that, but practically speaking, when you have the demise premises, it is using the development rights that were like, I don't know, I forget what the numbers are,
Well,
in terms of creating the demise premises.
I must disagree, Your Honor, because again, if we look at Solo, that provides our guidance. It says development rights are used in a special way, and it says that they are used in a way adjacent to a fee interest or a leasehold interest. And that also distinguishes possession of the demise premises to the way the development rights are used. So Solo basically guides the way as to how this court should rule, Your Honor. And what's missing from the lease basically guides what should have been put in, that the landlord reserved the development rights. They failed to do so, and as Solo says, that's their mischance.
Thank you. You have a question?
I guess I'm just, your argument is so unusual. That's all I can say, because termination of a lease has legal consequences. It has actual consequences. Again, you're asking us to read something that's not there.
Well, I agree with you, Your Honor. This is a matter of first impression. It is very novel. And my adversary says in his papers,
I don't know that it's first impression, counsel.
well, the lease terminates, but it doesn't say what reverts. It only says that the demise premises reverts. It never says that the actual development rights revert. And also, again, I refer the court to Solo, which says without that clause for reversion, those air rights cannot revert back to the
So, counsel,
landlord.
let me just ask you, have you found a case that says that a lease that is the demise premises doesn't include the development rights? Because every case that I've seen and every case that I've done so far includes it. So have you seen any that separate them out that way?
Well, my adversary doesn't cite any,
No,
but
I'm not,
again,
right. But I mean, look, demise premises generally, and I think if you look at a porn book, would include development rights. So I'm curious as whether or not you think your definition is something that we've adopted or thought about or even anyone would say is reasonable.
it's not my definition, Your Honor. It's the Solo court's definition.
No, it's not. None of us think.
Okay.
I should only speak for myself.
Okay.
I don't think that that's true.
Because this
But
is
so again, I'm going to ask you, have you seen any cases where a court has said that the demise premises doesn't include development rights?
no, and I haven't seen any cases
That's
that
just
say
what
that the demise premises includes them.
And what is it that you're claiming that you paid for over the 75 years to own the development right?
Well, the claim is that we were paying for the use and occupancy of the land and the building, and purportedly there was this portion that was to pay for the development rights that were
Right,
also
you
being
can
leased.
use an occupancy of those, right? But what are you saying you paid for the ownership of them? Anything in the lease about that?
There's nothing in the lease about that.
Anything in any document between either parties that would indicate that you actually paid consideration for the ownership rights as opposed to use and occupancy?
They don't need to, Your Honor, because the actual lease itself,
You don't have to pay for the development rights to own them straight up?
it was part of entering into the lease, and arguably entering into this
No,
lease.
the lease is for a certain period of time. You're saying, no, not only did I lease them, I bought them.
No, we didn't buy them, Your Honor. We're not saying that. It was leased, and by operation of law and the zoning resolution, a leasehold interest of more than 75 years causes the party that uses those air rights first to own them. So we're not saying we bought them. We're saying that the operation of law created that ownership. Your Honor.
Operational law. Okay, let's hear from your advocate.
Thank you.
May it please the court, Zachary Zwillinger for plaintiff respondent, 862 2nd Avenue, LLC.
I'm going to ask you, let's leave the law of the case issue aside for a moment, and let's
Yes.
talk about the merits of whether or not the development rights, used and unused, were reverted at the termination of the lease. And obviously, you think that's the conclusion. Just tell us why.
Sure. So under Section 1210 of the zoning resolution, It provided that for the purposes of that provision, ownership would occur for a lease that lasts more than 75 years, and that was the case here. But it was only for the purposes of that section. It didn't convey ownership itself. Moreover, the document that's at issue in this case is a lease. It says it's a lease at the top. It's for a specific period of time. And like all leases, it's a temporary transfer of the use of certain rights. So there's nothing in the lease that would suggest there's a permanent transfer of ownership.
I don't understand your argument that the statute doesn't apply. I guess that's what I'm asking you. Why doesn't the statute apply and state that because you use those rights and you had a 75-year lease, you own them now?
Because the statute only provides that the lease, you're able to use the lease development rights for the life of the building, and that's what the...
Oh, for the life of the building. I see what you're saying. So you're saying that doesn't equate to, and I own them. It just means as long as the building's there, you get to use them.
Correct.
And the Supreme Court didn't say that the move-in here doesn't get the right to use those the development rights until the building goes down or something else happened, right? We all agree that the statute applies at least to that extent.
Correct. So the idea is that...
Now I get it.
The purpose of Section 1210 was to allow for control for a long enough time so that the building could be in common ownership. And so the drafters of Section 1210 believed that 50 to 75 years would be long enough. Now that 50 to 75 years has passed, it's clear that buildings will last longer than that, and so it's appellant's responsibility to keep the lease going, and indeed under this particular lease, they can extend the lease up through to 100 years.
So as I understand the argument, one of the main arguments is the demise premises. The definition of demise premise does not include the development rights that were actually used. So the termination of the lease means you only get back, you get everything back but the development rights. How is that so?
It is inherent in a lease that it's a temporary transfer of rights. There's nothing in the lease that would suggest that there's a permanent transfer of rights. It's just not what leases are about. The lease
He's attempting to carve out from the demise, he's trying to create the development rights as a permanent transfer by saying that it's not part of the demise premises.
Correct, and that's just inconsistent with how leases work. They're a temporary transfer of rights. Now, under these circumstances, because we understand we're not able to take appellant's building down, we've asked for reasonable and practical relief. While their building is in place, then they can essentially hold our development rights hostage, and we should get use and occupancy during that time. When their building comes down, and of course that'll be their decision because they'll be the ones that decide to redevelop the building, then essentially the used development...
What happens under your scenario on redevelopment? Because that is identified as a triggering event. What happens?
So at that...
Are they held hostage? They can't redevelop it? Or if they redevelop it, then what happens?
When they redevelop it, they're essentially no longer using our development rights. As a result, they should revert to us because as this court held in the prior appeal, we own them. And that would be...
What do you do with them? What are they to you?
So then our property currently is improved with a 1- or 2-story building. When they revert back, when the use of those rights revert back to us, then we can use them to build our building up to the full 10 stories that we would otherwise be able. We're not able to do that now because under city planning rules, the used development rights can't be used during the life of the development. And so what we say is, we understand we can't take the building down. We wish we could, but we can't, especially in this case because appellant's building is filled with UN missions that have diplomatic immunity. So we'll get use and occupancy for the development rights while they are still used in their building. And then when the building comes down, then we can get them back.
So as long as they keep the building up, that's it as far as the used development rights?
Correct. We are not able to use them while their building is up. When they decide
You're essentially in a forced marriage.
Exactly.
I mean, you just want to stand by, and the minute that the triggering event happens, as Justice Gish says, that's when you get everything back.
Exactly.
But until now, I mean, it could be another 10 years, right?
It could be 20 years. We have no idea. That's why it's so important for this court to make clear to future purchasers and interests in future courts what has been decided in this litigation, because this is something that can be at issue for a very long time. Thank you.
Your Honors, my adversary just alluded to the fact that this trigger event may happen in 10, 20, or 100 years, and that is a big error that the lower court made. They created this order that has no finality, has ambiguity, doesn't have the clarity that should have, and the truth is, it leads into the fact that it can't be decided when these development rights can revert. They need to have the approval of the boards of standards and appeal. The respondents have never produced any evidence that the development rights could even revert. So let's say hypothetically that the...
But counsel, you would agree that the zoning resolution does not provide that development rights survive the termination of a lease, right?
It doesn't state that they survive the termination of the lease. However, there's nothing that states that they do survive.
You know,
we need to go again back to the Solo case. That provides the only way forward
so
here.
the way I look at it is that obviously your argument is that these development rights are mine. They belong to me. They've passed to me. Because at that point, then you could do whatever you want, because at that point you could take the building down and not worry about it because you have the development rights. And you don't want to do that because there's still, if we rule in favor of the respondent, you can't do that because the minute you take the building down, he gets the development rights back.
Yeah, the minute the building comes down, all the parties have to go back to the Board of Standards and Appeals and get a variance on what's
I
already
understand
filed.
that, but they're in a stronger position if, you know, if in fact, you know, they prevail on this argument that the development rights are theirs.
Right, depending on what the court decides, which is why I want to point out that the court should make a decision. And even if the law of the case applies, the Court of Appeals ruling in Adrias allows you to re-examine the same issue.
The lease termination really isn't, to me, it sounds like to me what I'm hearing is the lease termination really is not, you know, it's the triggering event is taking down the building.
We don't know when that is.
Yeah, we don't know when it's going to happen.
No, but they've also asked that.
But let me just understand this. Under their scenario, if they got back the development rights and you decided you wanted to take down the building and build something up, without those development rights, you wouldn't be able to build as big a building if they were right. That would really seriously impact the kind of building that you could put up.
That's an issue of fact, and that's an unknown that should not have been resolved on summary judgment, Your Honor. And that also...
We're just trying to understand what's at stake. We understand, no matter what we do here today, that we are going to see both of you back years hence on this, because there's a portion of it, there's only so far you can go here, and your claim is if at all.
Exactly, Your Honor. And also the relief that, you know, that my adversary just stated that, you know, they're asking for certain relief. I point out that they didn't ask for this relief in their complaint. And even I point out in our brief.
Well, they asked for a declaratory judgment, so they were I found that within the rubric of the relief to declare who owned the development rights now that the lease is terminated, of which there is no dispute.
There's no dispute the lease is terminated,
Right.
but they can't, under a declaratory judgment, ask to compel the appellant to do something. That would have to be brought under some kind of injunctive relief, which they didn't do, Your Honor.
Counsel, so the lease is terminated not because of the whim of the landlord, but because your client didn't pay the arrears. And your client's argument is, I didn't pay the arrears, but I owe all of the stuff up above.
Correct. My client didn't pay the arrears, regrettably. That is their mischance, so to speak. However, the rule of law still applies. And there's a zoning lot, which, like Solo says, is separate and apart from the fee interest and the leasehold interest. So one thing technically does not have the same thing to do with the other.
The most unusual case. Thank you, gentlemen.
Thank you.
Kingstown versus CPI Property. You can proceed, Counselor.
Thank you. May it please the court. Matthew Schwartz for the appellants. New York courts have jurisdiction over the defendants in this case, which concerns their defamatory press release, which was targeted at investors and potential investors in New York, which was part of a...
So what's your basis for your argument that it was targeted towards investors in New York, where the original distribution was not in New York? You know, it was in Europe. So how can it be what's the strongest argument for your claim that it was targeted to New York residents?
It was not, there's no allegation in the complaint that it was originally targeted in Europe. What the allegation is that the way that this company caused the distribution in New York was that they engaged originally with the German service that contracted with Bloomberg to distribute it in New York.
Equally all around the world, everywhere.
No,
Why New York?
That's not what the complaint says either. The complaint describes the company, the German company, as having global reach, but the explicit allegations in the complaint is that it was targeted at the New York bond market. You can see that in the press release itself, right? In the press release and in the defendant's subsequent statements, they say over and over again that their audience is the financial markets, is the bond markets, and they are distributing purely English language presentations. Hundreds of English language press releases, dozens of English language...
Isn't English spoken throughout the world, though? Isn't English a primary language everywhere in the world?
Not in the Czech Republic, not in Luxembourg. I mean, there is no other jurisdiction in which it makes sense for the defendants to expect to be sued. It's not just that these communications were expressly targeting investors in New York. It's not just that it was part of not just one communication, but a multi-year investor relation campaign. It is also the case that the statement concerned a New York domiciliary, accused that New York domiciliary of committing fraud on a New York court in connection with a New York lawsuit that concerned business transactions that were negotiated and consummated in New York.
But counsel, I don't understand why this rises to the level of defamation if you could have simply countered with the fact that a Luxembourg regulator found that, yes, there had been a series of fraudulent transactions undertaken by VTech and his co-conspirators.
Right.
Why is this just not normal trash talk in a press release?
It certainly is true that in this case, there was a finding by a financial regulator in Europe that the defendants conspired to essentially commit a fraud. But courts in New York routinely find that press releases like this, that comment on litigation but go beyond the litigation and accuse parties of wrongdoing and bringing cases in bad faith, are actionable. Obviously, this wasn't briefed to this court and it wasn't decided in the court below. But I would point, for example, to the Long case, which was cited below and which appears at page 426 of the record, in which now Circuit Judge Lynch held that it was actionable defamation after employees of a company sued for discrimination, when the company then sent an email to all other employees saying they had made up their claims, it was based on fake documents.
Those are employees. We're talking about business, right? We're talking about an entity that has been found guilty of wrongdoing, and you're taking their press release at face value and saying, oh, people believe this and we're damaged?
Well, I suspect when my friend gets up, he's not going to agree that his clients were found guilty of anything, and he will contest those findings, and they are contesting those findings in Europe. So, while certainly we think that our allegations are factually correct, the defendants accused in a press release targeted at New York, my clients, of committing a fraud on a New York court.
So, counsel, let me just ask you, didn't the press release go out to 20 international markets?
We're getting back to the jurisdiction question. Right.
Right. It went out to 20 markets, right?
I'm not sure which
Other than you saying it was targeted to New York, it was sent to a German press person, correct? In Germany.
It was contracted through a German newswire. There's no allegation that it was...
And did it go out to Only New York or other outlets?
There is,
Do you dispute that it went out to 20 news outlets?
I'm not aware of what Your Honor is relying on to say 20. There is not an allegation that I can think of in the complaint that says that it went anyplace other than New York. As a factual matter, I'm not saying it only went to New York.
Yeah, but when it comes to a jurisdiction, we can look a little beyond the complaint. And I know you say that, but that's very conclusory. The other problem is that in New York, we actually have a heightened standard for long-arm jurisdiction than we have for other kinds of torts. So you have to overcome that hurdle. I see that you rely a lot on the fact that ultimately one of the outlets, the news outlets, was Bloomberg. And I have, you know, a head-scratching moment on that, because that is really an international organization. It certainly would go to the English-speaking population who are interested, let's say, in just bonds. Why does that target New York? Why is that New York?
Because that's where the money is. And there are allegations.
Is that it? So in other words, because New York is the financial center, that consequently we could take long-arm jurisdiction over this stuff? That's fascinating, because that is news to me.
That's not,
I wish it were true.
that's not the argument, right? The argument is that these defendants have a history of soliciting specifically New York, including my clients, which transacted business with them here. And I'd ask, I realize my time is over, but let me just phrase it to the opposite.
You know what you're going to do? If you're going into a new point, you can reserve it. You can reserve it for rebuttal, okay? Because you're really way over your time. I know you see your time is over. I certainly see it's over.
I do see it. I was going to say one more sentence, but I can say it.
Right. Hold it for rebuttal. Hold it.
May it please the court, Your Honors, I would have allowed Mr. Schwartz to have that sentence, but I'm afraid that I wouldn't have enough words myself. But I really do want to point out.
I just want to ask you, is there record support for the fact that this press release was not just sent to New York?
Yes, Your Honor.
So tell us what.
Judge Scarpello, let me just read from the complaint, because Mr. Schwartz said that he was not aware of what was alleged in the complaint. So let me just clear this up. Paragraph 43 is at the record at page 27. It says each of the press releases was uploaded to CPI-PG's website and disseminated on the internet. They were thereby carried throughout the U.S., including New York County. They are
the U.S., not targeted to U.S., not only New York. They were sent everywhere in the U.S.
And I continue, they are accessible to anyone in the world, including residents of New York County. And that makes sense, Your Honor, because my client, CPI Property Group, did contract with a German newswire, did draft this press release in Luxembourg, which is very clear based on the face of the press release itself, which, for Your Honor's reference, is on page 148 of the record, where it says press release, Luxembourg, and on the top it says DGAP. DGAP is that German newswire service, and it just so happens that it was picked up by Bloomberg. But the case law in this, in New York, is clear that where you have a statement that's alleged to be defamatory, and it's equally accessible to anybody in the world, not just New Yorkers, and it's not purposely directed to New Yorkers, that there's no jurisdiction.
Because there's no transaction in New York, right?
That's correct.
It's sent out in Luxembourg by a German company, and it goes out to everybody. So that's not transaction in New York.
That is correct, Judge.
The fact that you get it in New York doesn't mean it's a transaction. Is that what you're arguing?
I'm sorry, I didn't hear that.
The fact that someone got the press release in New York doesn't mean that you were transacting business in New York.
Well, it goes even beyond that, because there's no law that says that a press campaign in New York would constitute jurisdiction as transacting business unless, normally the indicia is, somebody came to the United States to do, or New York to do research for the press release. They met and hired a publication company in New York to distribute the press release. And I refer you to the Court of Appeals case in 2012, SPCA. It's very clear that where there's no such connection, it's diluted, and therefore you're not going to get jurisdiction under 302A1, which, as I would like to point out, and the bench knows quite well, that it is a high standard
So let me just interrupt you, please, for a second and ask you, as to this, and also as to the second prong,
Yeah.
that the defendant transacted business in New York that was connected to the defamation. Is there anything in the complaint that alleges that you transacted business in New York?
Only conclusory statements as found by the trial court, and that conclusory statement is as follows. The transaction of business, they allege, is that over years, CPIPG was conducting a press campaign to try to influence New York investors without naming an investor, did not identify any of them. And in fact, Your Honors, at the day that this press release was released in Germany, or Luxembourg, I'm sorry, Kingstown was no longer even an investor in CPI Property Group. They had sold their bonds in 2014, 8 years before. So they could not have been the investor who was influenced by the press release, and they don't identify any other investor who was influenced. And therefore, Judge Jaffe correctly found that that any statement regarding this nebulous influence on investors was too conclusory, too speculative, and she found it correct that the trial court, therefore, I'm sorry, she denied their request for jurisdictional discovery based on that. Your Honors, I would just like to point out another point, which is that Mr. Schwartz continues to say that the press release accused them of committing a fraud on the New York court. And again, I urge this court to look at that press release. It does not do that. That press release merely denied.
You know, I'm going to stop you there. I know we went in a little bit into the merits of the case, but quite frankly, when we're looking at jurisdiction, you know, whatever personal beliefs we may have in looking at how strong or not strong this case is, right now, I think let's just focus on jurisdiction.
Judge Gish, I totally understand that. Thank you.
Thank you.
I mean, so again, going to the nexus point, there is no nexus. I've heard the word nexus a lot today. The nexus would have to be a connection between the press release and some transaction of business in New York. The transaction of business in New York cannot be the litigation that the Kingstown plaintiffs initiated against my clients in the Southern District of New York, which, by the way, they initiated it, and by the way, was dismissed by Judge Cote.
Okay.
And I see my time is up.
Okay.
Thank you very much.
Thank you. Mr. Schwartz, you have your rebuttal.
Thank you. 3 quick points. First of all, I think if you listen closely to my friend's answer about whether there was evidence that the press release was distributed anyplace other than New York, the answer was no. What he said was, and what the complaint alleges, is that the press release was distributed in 2 ways. It was posted on a website, and yes, anyone can access a website. We don't rely on that. But it was also actively distributed, and it was actively distributed via the German intermediary through Bloomberg to New York with the intention of reaching New Yorkers.
So,
Wasn't it distributed to every financial market throughout the world? I mean, what's your argument, again, that New York as opposed to other financial markets in other places?
Well, first of all, that's what the complaint expressly alleges. Second of all, doing it English language only eliminates a lot of other things. Third of all, the face of the press release and the attendant communications indicates that the sole audience that they were trying to reach was the bond market. And that is...
the bond market only in New York?
It doesn't have to be only New York. I mean, that's my other point, is the court below applied a standard that said that it has to be of sole importance to New Yorkers and accessible solely here.
Counsel, I want to go back to the jurisdictional question. So the CPLR tells us that defamation cannot form the basis for tortious act jurisdiction. So we go back to the same question: what business or what transactions were conducted in New York?
So I think there are at least 2 different kinds of business that were transacted to New York that have a nexus to the defamation. One is this multi-year investor relation campaign, and if you look at cases like PDK, you'll see that courts have held that a pattern of solicitation in the state is sufficient to transact business. 2 is the underlying transactions.
Wait, are you saying there were solicitations of bonds in this state?
Yes.
And that's connected to what?
This entire multi-year investor relations campaign was intended.
Got it.
And that goes back to, two, they actually solicited investments and closed investments from my clients in US dollars through New York banks, custodied in New York banks. And that may have been a long time ago, but those transactions are the actual subject matter of the jurisdiction. And so I take the point that New York doesn't want to have expansive, ever-reaching jurisdiction over defamation. But think about it the other way. The proposition that the defendants are advancing says that a foreign domiciliary, so long as they do two things, can freely defame a New Yorker. One, they have to use a foreign intermediary, and two, it's got to go someplace other than New York. And if
No,
they
it's
do
not that anyone can ever defame, it's just where you bring your case. Right. That's it. And no one's saying, none of us are saying, good, defame anyone. It's really just about where you have to bring your case.
There's no place else to bring this case, though.
Oh, well, okay.
I mean, that's the bottom line.
Where is the defendant located?
So Mr. Vitak, according to the defendants, lives in the Czech Republic, in the United Kingdom, and in Switzerland.
Can't sue in the UK, which has even stronger, way stronger defamation laws than we do.
CPIPG resides in Luxembourg. If they want to consent to jurisdiction over this suit in the United Kingdom, we would be happy to do that. But it's a suit about New York and New York conduct.
All right.
Thank you.
Thank you. Thank you both. And our last case on the calendar, People versus Dijon.
Good afternoon, Your Honors. Excuse me. Good afternoon, Your Honors. This is Pauline Cernick for Appellate Giscard Degene. The SOAR court below erred in assessing Mr. Degene the full 30 points under risk factor 9 when he only has a prior misdemeanor for forcible touching. And he,
Why isn't forcible touching a sex crime under the statute?
forcible touching is not a sex crime under the statute because under Correction Law 168A2B, forcible touching is only a sex offense and registrable when there is either a minor involved or it's
Why
a
does
sex.
it have to be registrable, though, to be a sex crime? What's the tie-in between being a registrable sex offense and being a sex crime?
Yes, Your Honor. So if we look at the guidelines, they use the term sex crime and sex offense interchangeably throughout. I can give a few examples, but for example, for factor 8, they say age at first sex crime in the header. And then right underneath it, it says, offender committed a sex offense that subsequently resulted in the conviction of a sex crime at age 20 or less. So they're using it in the same sentence interchangeably, and additionally under factor 9, even though they don't use it in terms of points, they discuss when there's a presumptive override.
Counsel, what about our holding in People v. Garcia, which is a 2021 case out of the 82, the second department, which said that forcible touching and other misdemeanor sex offenses are properly considered a sex crime?
Yes, Your Honor. So in People v. Garcia, it actually isn't clear from the case if there was a minor involved, but regardless, we would say that it is not binding here, and that this court should instead rule that it needs to be a sex offense in order for there to be clarity to the guidelines. Since sex crime is also not defined anywhere, there is a statutory definition for sex offense, but a sex crime can be many things. That is, it's very ambiguous. For example, would a petty larceny be considered a sex crime when there's a sexual element involved? We don't know. Meanwhile, a sex offense is very clearly defined by the legislature, and they took the time to decide that a forcible touching, when it's not against a minor and it's the first time, is not considered a registrable sex offense. Additionally, going back under Factor 9, they do discuss presumptive overrides for Level 3s, and there they clearly use the term prior felony sex crime conviction is necessary for a presumptive override to Level 3, but then 2 sentences down, they again state a prior felony sex offense conviction is necessary. So again, they're using it interchangeably, and they mean the same thing. And we would point to that this court should hold up People v.
Let me ask you a question. So if If that misdemeanor is not capturable on the RAI, well, under 9, where would it be capturable? It's certainly relevant conduct, isn't it?
Yes, Your Honor. So it actually would be captured under Factor 9. It'd be captured for 5 points under a prior misdemeanor history. So it would be relevant insofar that it is indeed a prior misdemeanor. It is just not a prior sex offense misdemeanor.
So wait, so your argument is that we should treat it the same way as we would like a marijuana offense or a turnstile jumping?
Well, Your Honor, I would say that the legislature wrote out and thought about which crimes are sex offenses, and they clearly made a carve-out for forcible touching when there is not a minor involved and when it's the first time. So if there was a minor involved, it would get the full 30 points. But yes, when it comes to public safety, they clearly thought that forcible touching for the first time, not a minor, is not something that is of such heightened risk that should be registrable. So I think that speaks to that point.
Again, I don't know where the connection is to registrable versus being a sex crime. Because they could have easily said a registrable sex crime if they wanted to in the statute, and it doesn't say that.
Well, Your Honor, if
But not the statute.
Oh, I'm sorry. Well, Your Honor, for other points, the guidelines do use sex offense, and they do use it for the scoring of other points. If it said registrable sex crime, then it'd be very clear that that is a sex offense, because a sex crime, again, it's ambiguous. We don't know what it is. But a sex offense we know has to be registrable under SORA and under Correctional Law 168A2B, which is where, again, the correction law states that the forcible touching is not a registrable offense, and it clearly states that as a carve-out to the list of sex offenses. Additionally, Your Honor, I would just like to point out for the language of Factor 9, sorry, there's a tickle in my throat. Under Factor 9,
A lot of coffers today. Go ahead.
yeah, I think it's the masks. I'm sorry it's when you're up here. Sorry. So under Factor 9, it does say misdemeanor sex crime and adjudication for a sex offense. If respondent's theory is true, then felony sex crimes are not scored under the 30 points, because then something like a sexually motivated felony, which this court has held, is not a registrable sex offense, but would be considered a felony and a sex crime. It's clearly being left out by the language of Factor 9. We think that the reason that it states misdemeanor sex crime is because previously it had listed, in the beginning of Factor 9, it lists multiple felonies that can be adjudicated points for, so they just wanted to clarify that a misdemeanor sex crime like forcible touching, when there's a minor involved, could be scored points. Thank you so much.
Thank you. Go ahead, you can proceed.
Thank you. Good afternoon, and may it please the court. Catherine Murata for the people. Here, defendant was properly designated a level 3 sexually violent offender. His defendant's prior forcible touching conviction from 2013 is a misdemeanor sex crime, and he was correctly assessed 30 points under Factor 9 and 10 points under Factor 10 for that conviction. The SORA guidelines state that an offender will be assessed 30 points if his prior criminal history includes a conviction for the Class A felonies of murder, kidnapping, or arson, a violent felony, a misdemeanor sex crime, or endangering the welfare of a child, or any adjudication for a sex offense. Here, forcible touching is a Class A misdemeanor whose elements are patently sexual in nature. The intent of SORA is to assess an offender's risk of reoffending and the harm of his reoffense. To narrow Factor 9 to just sex offenses would undermine that intent, as it prevents courts from assessing sexual behavior that is relevant in defendant's risk of reoffense. I can also discuss the downward departure point if the court wants. Otherwise, if there are no further questions.
No, I want to ask you one question. Do you think it makes sense to distinguish between forcible touching for a 15-year-old and a 19-year-old. So does it make sense to distinguish whether or not to add the points because the forcible touching is against someone, a minor or an adult? I mean, that's what counsel is arguing, that we should distinguish our precedent on this on the ground that in the case, I think it's people Garcia, right? And the second department in Valdivia, and the lower courts in Valdivia, and counsel is saying we should distinguish those cases because those are all minors. And I'm asking you, what do you think about that?
Well, the decisions in those appellate term cases, those were not minors in those cases.
Only one case was it? I think it was the one main case, right? The appellate case was a minor.
I don't believe so. The appellate term cases that I have in the brief, they all squarely address the issue at point here, and they all are adult victims for the defendant's prior forcible touching conviction. Even though the decisions may not explicitly state the facts in their decision, I have read the briefs from those appellate term cases because they're from.
No, I think we're talking about
Garcia's
yeah, Garcia. Garcia is the one that I'm talking about. That was a minor, right?
There's no indication that that was a minor in that, in that case.
Okay.
It's just there wasn't enough facts in the decision to determine either way, but I believe that one was adult victim as well.
Okay.
If there are no further questions, we ask that you affirm defendant's level 3 adjudication. Thank you.
Thank you. Any rebuttal?
Thank you, Your Honor. I would just want to point out one case that we cite, People v. Lancaster, that was also a second department case. And there, it was an individual convicted with assault with intent to commit rape, and it was by a military tribunal, but the court there conducted the same analysis that we're arguing for, where they wanted to see if it was a sex offense. And they found that that conviction was not a sex offense because it was not under the SORA guidelines, and therefore, he should only be awarded 5 points for prior misdemeanor history, which is exactly, and there the conduct is much more serious, I would argue, than a first forcible touching that's not against a minor. So, Your Honor, I believe that the correct holding is like People v. Lancaster, which has a similar analysis to what we're arguing here. Unless there's any further questions, I rest on my brief.
We're good. Thank you very much. Thank you both for being the last ones on the calendar and being so patient.
It was nice meeting you. Like, I feel like my mask was just, I couldn't speak.
Careful.